Pre-Independence Day function celebrated by the Community of the Way, CCR, Panjim Prayer Group, and the Goa Jesuit Social Action to commemorate the eve of independence. From the sacrifices of the past to aspiration of the future, from the depths of history to the heights of progress, we are celebrating our journey as a nation. On the eve of Independence Day, let us celebrate the freedom we cherish and the unity we embrace and work towards a brighter and more united future. May I invite Father Joe Nazareth to kindly lead the main speaker, Advocate Shivan Desai, to the podium and give him a seat here, and you seated next to him. May I now request Father Joe Nazareth, Superior of the Jesuit House, to speak on the topic Preamble of the Constitution, followed by the recitation of the Preamble. Over to Father Joe.
Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age, says Dr. B.R. Ambedkar. Dear friends, we are gathered together and to appreciate each other's presence over here. Amongst us, we have Advocate Shivan Desai. Thank you for your presence, Advocate. The preamble to the Indian Constitution clearly expresses the importance of our nation's guiding principles. It highlights the Constitution as a symbol of our country's goals, values, and promises. The preamble can be seen as the heart of the Constitution, showing its key role in shaping our country's laws, rights, and duties. It also stresses that every citizen, including children, should know the rights and duties outlined in the Constitution. Pandit Thakur Das says, the preamble is the most precious part of the Constitution. It is the soul of the Constitution, the key to the Constitution, a jewel set in the Constitution, and a proper yardstick with which one can measure the worth of the Constitution. Today, let us come together and discuss and reflect on the importance of the preamble to the Constitution of India and the 3 new criminal laws. Now let us stand together and recite the preamble to the Constitution.
Thank you, friends. You may sit down. Thank you, Father Joe. May I request Suzette Ferreira, the sector leader of North Zone, to introduce our keynote speaker, Advocate Shivan Desai.
Advocate Shivan Desai is a distinguished personality amongst us. He has studied his SSC and higher secondary in Goa. After that, he moved to Pune where he did his Bachelor of Social Legal Sciences in ILS Law College. After that, he did LLB in the same college. He did his LLM also through Pune University. And he has done several diplomas. Diploma in Human Rights from Indian Law Society, Pune. Diploma in Medical Jurisprudence and Forensic Sciences, and a diploma in Corporate Laws. He attends the Honorable Supreme Court of India and also Honorable High Court of Bombay at Goa, District and Trial Courts in Goa, National Green Tribunal, New Delhi and Pune, and National Company Law Tribunal in Mumbai. His areas of practice include Constitution of India, civil law, company law, income tax laws, labor laws, arbitration, and environmental laws too. Besides, intellectual property law, mining law, consumer laws, criminal law, including Prevention of Money Laundering Act and Prevention of Corruption Act. He is also into securitization law and international commercial law. He is fluent in various languages, English, Hindi, Marathi, and Konkani. Let us give a warm welcome to Advocate Shivan Desai.
Thank you, Suzette. May I now request our prayer group leader, Winston Culasso, to kindly present a potted plant as a token of appreciation for giving his time to us, to Advocate Shivam Desai. Without wasting much time, may I now invite Advocate Shivan Desai to enlighten the audience on the preamble and the 3 recent criminal laws.
Good evening, everyone. First and foremost, let me express my gratitude to everyone here. Well, if at all there is one occasion we should celebrate in India, it is this occasion, because this is the document which really defines our country, which really protects the fabric of our country. And this, in fact, is the momentous occasion that I think everyone, every citizen of India should celebrate with gusto. And that's the reason why I was really elated when I got this invitation, thanks to Rui. When we talk about the Constitution, and this is a very, very important topic, I think every seminar on law should start on Constitution. Keep aside everything else, all the other legal principles. But since this defines the country, this is one document, as someone rightly said in the beginning, which everyone in the country should be aware of. You may not be aware of the nitty-gritties, you don't need to be. It is not a lawyer's document, it is a people's document. And therefore, an effort should be made. I really believe an effort should be made that to understand what are the basics. You don't have to get into all the complicated theories and concepts. The question is, what is it that the Constitution gives you? Because it's only if you know what the Constitution gives you, I think people will stop reacting. As long as you know that there is a document which will survive generations, and that's how Supreme Court has preserved it, and I'll come to that, you will not react to anything. You know that this country will support you, will secure you, and your rights are protected. And that's the reason why I was happy that with all the criminal law and the advance and the changes in criminal laws, this was taken as a start, or taken to be the start of the seminar or the talk. And the most important part of the Constitution is the preamble to start from. I will make it easier for everyone. We've already read the preamble, so we don't really have to get into it. But the most important part of this preamble are the first 4 words. It's "We the people of India." And that's the founding principle. You need to understand that the constitution is not something that a particular assembly, legislative assembly gave you. It's not something that Dr. B.R. Ambedkar gave you. It's not something that the then provincial legislature gave you. It is something that the people have given to themselves. Because when the constitution was formed, there was a committee, there was a provincial legislature, which was supposed to represent the people at that point of time. So the representation is not important. They elected or nominated certain members who they felt would be in the best position to express the will of the people at the time when Independence Act of 1947 was passed. So they felt that, well, let's have a drafting committee, let's have a provincial legislature who will debate on this and give us the founding document. And that's where the constitution stems from. So first 4 words or first 5 words are the most important part of this preamble. It's the people of India. It's basically the authority vests with the people, and people delegated these people, the concerned legislators at that point of time when the constitution was framed, to frame a constitution but make sure that you protect all our rights, and we give you that mandate. Fortunately for us, there were people of responsibility, there were people with scruples, there were people of ethics, and that's the reason why we have this preamble to start with, because this preamble to a great extent defines what are the basic tenets of our constitution. It makes for a reading which I think all of us can comprehend. It's not very complicated, but whenever you have to understand what is your right in this country, you need to understand that it is, the right is with you. People have rights. People basically run this country through various means. There are people who nominate their representatives. But not for a moment should anybody think that you are at the mercy of any particular government or any particular individual. It is a right which vests with you. So they have kept faith, and they've enunciated, or they have stipulated these principles. And as I said, the sanctity comes from the people. And the other important aspect of this preamble is the sovereign, socialist, secular, democratic republic. So when you say sovereign, it basically means we are free of any external power. We do not rely on any external power for anything. So you are as independent as it gets. We don't, unlike just to give an example, if you go to a Scotland or some parts of UK, so they are not sovereign. So they have a level of independence, but it's curtailed. So here in this case, this country can define for itself how or chart out for itself the course of action. They are not dependent on any external power. The second is socialist. Socialist is a very utopian concept. I'm sure all of us have some kind of understanding of what socialism is. Socialism basically means that the government or the state should strive to weed out the inequalities that are there in the society. Inequality of income, inequality of status. And that is why when they said that, when they included this word socialist, it pretty much defined how the government perceived or wanted this country to move ahead. Because at that point of time, the country was grappling with a lot of insecurities, there were inequalities, which continue even today. So it's an ongoing process. So it's a sovereign country. Socialism is one of its ideals. So as much as we are still struggling with inequalities in the society, going forward, the point is that this should be one of the aims of the state, is how the preamble captures the basic intent of the country. Then secularism, again, it has different connotations, but in simple terms, it basically means that you respect every religion. So that is made or drafted into the preamble. It wasn't there earlier. The concerned concerned government at the relevant time, somewhere in 1970, around 76, thought it fit that in view of the diversity of this country, as much as secularism is part of the constitution, we should also incorporate secular as an expression or as a word in the preamble, so that the message is loud and clear in case there are some dissenting voices, there is some disquiet, there is some rebel rousing. Message is clear that this country is a secular country. It strives to achieve its ideals as a secular country. And come what may, one need not react to anything and everything. What is the ideal is there in this country. So no particular entity can change this. Then democratic, of course, that basically means that you can participate. It's a participatory electoral process whereby you elect your representatives who ultimately represent you. So it's a democracy, which is a very fundamental aspect of our country. India, in fact, is one of the largest democracies in the world. And the way it functions, I'm not sure how it functions, but it functions. And then, of course, a republic, where the head of state is, again, not a king or a monarch. That's why the word republic is used, because eventually we elect our head of state. So that is why, if you look at these 5 expressions, we the people and these 5 expressions, it says so much. So we have to give it to the concerned legislators who at that point of time crafted this particular premise or preamble in the manner that they did. But it encompasses possibly every virtue that one would want in a country which was formed more than 75 years back. The next is, the other expressions are pretty clear. It's justice, social, economic, political. It pretty much means that the justice will be made available to everyone, irrespective of a social background, economic background, political background, liberty to just have whatever thought process one wants to, any belief, any faith, and the equality of status and opportunity. That is where sometimes the reservation comes into picture. I think, but that's a topic for some other day, because reservation, I believe, is something that, according to me, is a requirement. It's an affirmative action, which is a requirement as on today, because you need to have level playing field. So equality of status and opportunities, where all those measures come in for upliftment of the downtrodden, measures taken to see that everybody has a level playing field. As much as people feel in the general category that, we are being shortchanged, we don't get our due, our children work so hard, they don't get the relevant quota. But you need to understand that you need to give equal opportunity to everyone, and that is when you're competing, not when you get the best of resources. So that's only one aspect of it. But generally, we believe everybody is born equal and should have equal status and opportunity, whether it's in the sphere of public administration, whether it's in courts, or whether in every walk of life. You should not be discriminated against. That is the highest virtue that one can imagine. And then the last expression, fraternity. Now, this fraternity is an expression which is there in very few constitutions. Even American Constitution does not have fraternity. So fraternity basically means a sense of, brotherhood, which I think is a very lofty ideal. And that is where you respect the dignity of the other individual, and that eventually will lead to unity and integrity of the nation. So although it's in about a few words, but it encompasses all the articles of the Constitution in a way that one can decipher what is the intent, what are the virtues of the Constitution, and what are the values that the Constitution protects and promotes. So now the next slide is only about the background, which is slightly technical, to say that this was amended in 1976, wherein the expression secular, integrity, and socialism was incorporated. So I've just given a very brief, as I said, I don't want to make it into a very technical kind of a talk, because as lawyers, we tend to get a little technical, use legal language. In fact, today in the newspapers, one of the ministers did object to one of the legislators who was a senior lawyer, saying that he speaks in assembly as if he's arguing a case. So I don't want to fall in that trap, and I remember even for my wedding, when I was inviting a very dear friend of mine, and I requested someone, have you just checked whether invitation is served on him? So he said, listen, it's an invitation, it's not a court notice that I'll serve on him, but yes, I have handed over the invitation to him. So that's where we fall in that trap, and I think I told him that I just want to make it as simple as possible, because I don't think, as someone rightly, I think he started on the right note, that it's not a legal document. It's a document, it's a charter. It's more like a citizen's charter, which everybody should be aware of. And you don't have to really get into nitty-gritties to understand what are your rights. So it went through some kind of a legal evolutionary process. Initially, the Supreme Court said that no, it is not exactly a part of the Constitution, because they took it like any book. It's like a preface. If I want to read this whilst interpreting Constitution, let's keep this aside. Let this just be an introduction. But then subsequently, Supreme Court, if I may use the expression, corrected itself. And they said, no, this captures the ideals, the values. This is the foundation on the basis of which the Constitution is mounted. And that's why you have to take this as a part of the Constitution. So that happened in the very famous Keshwananda Bharati case, where they said that, no, we will take this preamble as part of the Constitution, and this judgment protects the Indian Constitution in various ways, but that's very technical. This judgment is, a lot of people have tried to understand it, but they're still grappling with it, because there are multiple different opinions, and you have to kind of collate every opinion and come to one particular principle. But the one specific principle in the context of what we are discussing today or debating today is that it said very categorically, this preamble you can't change. This preamble is part of the Constitution, and nobody can interfere or tamper with it, because this will be taken as, if you want to amend this, you are amending the Constitution. So that is where Keshwananda Bharati came to I wouldn't say to the rescue, because nobody was trying to tamper with it at that point of time, but you never know going forward if there is a case for anybody tampering with the ideals, because this is taken as a base. Now what they did additionally was, they said, well, it is part of the Constitution, but we'll take it one step further and say that it is part of the basic structure of the Constitution. So that's why you can't amend it. So at one point the question was whether we can amend it. They said, well, it's part of the Constitution. You have to only amend in terms of the Constitution, which is a very, very arduous task, which is close to impossibility, because if you want to amend the Constitution, you need almost about 3/4 majority in the House, both the houses, as also 50% of the state. So it is not, constitutional amendment is not easy, because you don't get that kind of support. But they went one step further and said that, listen, we are not even trusting anybody else in future, because you never know, one can always gather the numbers and have 3/4 majority and 50% of the states also. So we don't trust anybody. We will bring this into a basic structure concept, so nobody can change it ever. So it's quite interesting that as much as this Constitution is supposed to be an organic document, it's a document which is supposed to evolve with time, there are certain ideals which Supreme Court said, and fortunately for us, that they said that can never change, and nobody can take that away. One of such principles is the preamble and the virtues of a principle, wherein never ever can anybody tamper with it. So this part of there are certain portions of the Constitution which have immunity from any legislative interference at any point of time. So which includes the democracy, free and fair elections, the preamble, the right to equality. So they have expanded it in a way that whatever are the virtues of the preamble, they will survive everyone, generations, and till we have India as a country in this world, till the world survives. These principles will not change. So the point really I'm trying to make is that you don't have to understand all these cases. All you need to know is that nobody can take away your rights. Nobody can discriminate against you. Nobody can, on the grounds of religion or otherwise, impose anything on you. Nobody can take away your freedoms, which are enshrined in the Constitution. So that remains. So for every citizen should be aware. You don't need to get a degree in law to understand this basic principles, and you should be an aware citizen so that one, as I said, you don't react, and secondly, you can enforce against whosoever tries to practice this kind of any kind of a discrimination or interferes in any of the protected rights, because the freedoms enshrined pretty much, according to me, pretty much cover the dignity of every individual and every citizen of this country. So that is so much, that is what I had to say about the preamble. Then the other three topics that I'm covering, and I will take a very practical view of this, keeping in mind the audience. Not getting into technicalities, but since these are legislations which have just been introduced, they can be a little unnerving for citizens, because over a period of time we are used to being familiar with the basic criminal laws and whatever are the basic laws. So if you look at the Indian Penal Code, it goes back to 1860. The Criminal Procedure Code goes back to 1890. So Indian Evidence Act also goes back to 1910. So there were existing legislations which have stood scrutiny for a century. And then we had these three legislations which were enacted. So that's why there is a little bit of discomfort, I think, in the society, even in the lawyers community. But that I think is not justified. You can't say that I don't want to go back to the drawing board and study the new sections, and I'm used to the old sections, and that should not be the reason why you should really be critical about the act. Although that's one of the criticism, that you've just changed the sections, and because of which it makes it difficult for lawyers, they'll have to go back to the drawing board. Now I don't think that's a fair criticism. Now on we can have our opinions on the names given, but there was a thought process behind it. Some people may agree, others may not agree. They felt that the Indian Penal Code, and the Criminal Procedure Code and the Evidence Act was enacted pre-independence, and to a certain extent they indicated some kind of a colonial hangover. On a personal level, I don't quite agree with that, but be that as it may, I really can't find fault with them renaming it, making it very India-centric, even in terms of the nomenclature. So the names have changed. BKA is the Evidence Act, BNS is the Penal Code, and BNSS is what we call is the Procedural Code. Now, some advantages. See, we need to keep in mind that ultimately with time and as society evolves, the crime also, if I may use the expression, evolves in its own way. It gets more horrific. They come up with ways and means to subvert the investigation, to subvert the law. So there was a need. There was a need to, one, redefine some crimes, introduce some crimes, as also introduce some measures to deal with these crimes. So when they introduced the act, per se, I feel that was required. If you read newspapers nowadays, there are certain crimes which wherein your blood really boils, because you can't imagine that people can be so inhuman. They are really horrific. And it appears that depravity has reached a different level. So it really shocks one's conscience that when you read papers. So to deal with this, whether it's got to do with technology, it's got to do with overexposure and a degeneration of the societal values or the mindset, whatever you call it, the fact of the matter is that we are living in a world where crime is rampant and crime is redefined. So that's where they have also tried to make it a little simpler. There are chapters on offences against women and children, so they have streamlined it by making it part of one. From 511 sections, they've come down to 358. That again means you can make it a lot more tighter. You can't, reading 511 provisions by itself makes it quite an arduous task. And the last part is where there are other offences with regard to attempt, abetment and conspiracy brought together in one chapter. So this is more legal, where earlier there were different chapters dealing with connected crimes. Now they've tried to put it all together. So that's one positive. These are the three common positives. Next. So in terms of introduction, they've introduced this community service, which for petty offences, because there are various theories when it comes to punishment. One is retribution, it's eye for eye. Other is reformation, where people feel that someone commits a crime because there is some kind of help that he needs. It's not that every person is a born criminal. Either it's circumstances or his certain other factors which make him or her do what he or she is doing. So that's where the second theory is reformative theory. So that's where they've kind of given it a new look. They've trying to redefine punishments in some categories. If there are petty offenses, why incarcerate the concerned person? Let him do some community service. Let us see if he has a change of heart, change of mind, and he reforms himself. So that's where community service is brought in, which is in keeping with other developed countries like the US. Then hit and run. This is one of the major issues that is addressed. Hit and run used to be instances where people used to just escape. And then, so ultimately the offense was the accident. But the fact that you have run away was not really adding to the offense or the gravity of the offense. So that's where they have added this category. So if you see, they have really addressed, they've done some study and addressed the certain areas where people were taking advantage. So hit and run is added as a punishable offense. Next. Now, we've noticed many a times that grievous hurt was also made, it was an offense earlier. But then grievous hurt leading to a vegetative state. We've noticed many a times grievous hurt is somebody breaks someone's bones. But or he kind of interferes in some way whereby it could be a grave fracture, or he could lead to a state of, as I said, a vegetative state of permanent disability. So all this could not be put in one category. You can't say that somebody having a fracture and somebody else who has had a even more grave injury, and the consequences is that he is permanently disabled. You can't put them in one category. And that is what we were, as lawyers, were also grappling with. How can you just, keep both on the same plane? So that is addressed. Then we've seen so many accidents. They've tried to, earlier it was 2 years, even a rash or negligent act, which includes accident. We've seen so many accidents today wherein because of rashness and negligence, it leads to death. Or there are some other acts. It may not just be accidents, but for the purpose of understanding, accidents are routinely, which cause death, are routinely covered under this particular section. So they have made it from 2 to 5 years. So hopefully anybody indulging in any reckless act now knows that it's not just about 2 years, but it's more than double. That's about 5 years. So this is meant to be a deterrent. Many a times accidents, they are not with a particular motive. Nobody intends to cause any harm, but it's got to do with your reckless act. So that's where I think provisions like these should be put to the concerned people around you to say that, well, you may not be you don't have to be a criminal, and to qualify as a criminal, you don't have to really do anything that you intend to cause any harm. But if you indulge in a reckless act, there are serious consequences. You may not intend to do any harm, but it may lead to serious repercussions in your life. Because 5 years incarceration, there's very little hope for the concerned person, if he's young or middle age, or even for that matter, slightly on the higher side, for him to again accommodate himself in the society and then get his life going. So they, according to me, they have, it's a thought through. As much criticism as we see in papers and in courts, they've thought through certain aspects which is commendable. Then they have rationalized fines and punishments. So the fines were, 1890 code, 1,000 rupees, 500 rupees. It was unrealistic. So they have obviously enhanced those fines. Hopefully it should pinch, right? 500, 1,000, 2,000 does not pinch anybody nowadays. Next. Yeah, so women and children, if I have to broadly refer to these provisions, they have dealt with specific situations which are now the problems of society. So if you see the first part of the offense, false promise of marriage, employment, promotion, suppression of identity, it's specific. There are many a times these provisions were also misused at an earlier point in time of, as we call it, without consent. There was to be an intercourse which is considered as rape, but they've tried to define it to the extent possible so anybody who is in a relationship really understands what are his limits. Then there were different punishments depending on the age when it comes to even heinous offenses. So they have, again, to great extent, made sure that that differential aspect is also taken care of. So that is eliminated, and now there is no difference in punishment. If you commit a heinous crime, irrespective of your age, as long as you're above 18, you will have the same form of punishment. Even engaging a child, now, as I said, right, as we move along, and over the years, people have changed the modality. Now they use children, unfortunately. So because children don't understand the consequences, you can induce them, you can influence them. They really don't know what they are really doing. He could just be a carrier of a drug. For him, according to him, it could just be sweets. So someone like him, the person who has actually induced the child, is also made an offender. It should have always been the case, but they have introduced this. This protects the child. At the same time, it's deterrence, because you cannot use the child to commit an offense, so that you can try and cover up what has happened. So that's where they have introduced necessary safeguards and incorporated necessary conditions to make sure that there is deterrence. Then even children. Now, as much as I've spoken about the children being taken advantage of, sometimes the children, for whatever reason, maybe for whatever's out of circumstances, they don't have the education, or they have the education, but they commit crimes. And they commit heinous crimes. We have the Nirbhaya case also, and now, because I have a 5-year-old daughter, so we realize that because of exposure, they lose their innocence very fast. They are a little more mature at a very early age. They realize the consequences. So the whole purpose why a child was protected was which goes back to the past, and that was because they didn't know the consequences. So let's not pin criminal liability on them. They are children, they don't know the consequences. But today the situation is different. A 10-year-old child today, as compared to what I can call my generation, because generation keeps moving, even as a 10-year-old, we would be termed as innocent in relative terms. But today a 10-year-old knows a lot of the aspects of life, is aware of consequences, is exposed to so much that he should also be made accountable. So let's not hide behind the fact that 18 years, he's immature, go by the age-old norms. Norms have changed, crime has changed, children mature faster. That's the reason why even they should understand the implications of crime, and liability should be pinned on them if they commit a crime. That is, In Nirbhaya case, there was a juvenile. He kind of, I must say, he got away because there was a juvenile system, and they are when you are part of covered with the Juvenile Justice Act, then they don't really pin any criminal liability. They look at it more from the reformative way. So they have uniformly used the expression child and defined the expression child. Yeah, so these are the new offences. We've seen many situations whereby people who are outside the country, they facilitate or they influence crimes in India, and they feel that since they're out of the country, they'll get away with it. That is addressed. For snatching, normally you have this chain snatcher, so there was no specific offense. So they've incorporated that as an offense. We used to bring it within the fold of theft, but now that is a specific offense. And they've dealt with organized crimes and terrorist activities, which have been specifically defined under this. Yeah, so this is a category of new offenses. Like beggary has been introduced as an offense. In keeping with the changing requirements, they've also incorporated an offense with regard to importation of a person from a foreign country. It used to happen a lot earlier, which is child trafficking, because it was not fitting into any specific provision that they were trying to fit into the existing old act. And damage to property, lynching. If you see, there are a lot of mob lynching incidents that have taken place in the last 4 or 5 years, which could not be categorized. So we always had difficulty as lawyers. I'm not a prosecutor, but the prosecution had difficulty because they had to just pigeonhole a lot of crimes into particular existing sections of 1860, which were not updated. So that is when you try to pigeonhole it, fit into a particular category, what is not meant for, the prosecution fails. Anyway, the prosecution statistics are not very encouraging in India. So that's where they have identified additional crimes that plague the society, and I think that is a very, very positive aspect of this BNS. Next, they've deleted provisions with regard to sedition. An attempt to commit suicide, as ironical as it sounds, was an offense at one point of time, so they've deleted that. Otherwise, even an attempt was made punishable. I think that. So next, so that is all about the BNS, which is like the penal code, new offenses, new punishments, and a relook at crime, which I think was the order of the day. This criminal procedure code, it's slightly technical. I'm not sure that all of you all will really be employing it in day-to-day activities. But I've just made an effort to point out what are the broad changes that this particular act has brought about. To put it in a nutshell, it is only procedure to investigate. Criminal procedure code is basically for the prosecution, for the police, and for the lawyers. There is very little that a citizen has to do unless he's a criminal with this procedure. But the positive about this particular act is they have taken into consideration a lot of the modern methods of investigation, a lot of the modern tools for investigation and means of communication, so that the entire process can be expedited, the trials can be expedited, the investigation can be expedited. And as you must have noticed in terms of statistics, there is a lot of disenchantment in the society because the criminal cases go on for years, the witnesses turn hostile, prosecutions eventually don't succeed in their matters. So that was plaguing the criminal justice system, and that is where they have made changes when it comes to audio, video, electronic means and electronic evidence. So as I explained, since there is a community service is one of the punishments which is newly incorporated, they've given powers for community service to the magistrate. So the first one I think is something I'll just delve into. The first is with regard to an offense punishable less than 3 years. The person is infirm or above the age of 60 years. Without prior permission of the officer, not below deputy, person cannot be arrested. I think this is salutary. so a lot of people may just take note of this, not to suggest that this will come into play for you, but just many a time we see that the powers are misuse of arrest. Senior citizens, whether someone wants to take advantage, they influence the police, they possibly bribe the police and try to threaten senior citizens or create that sense of fear because they want them to submit to their demands in whichever form. So there is an extra layer of protection which is provided so that the police by themselves do not abuse their powers and they just don't go to a senior citizen and arrest them and threaten them with charges which are non-existent. But it creates a sense of fear because of which I've seen as a lawyer, a lot of senior citizens, they just submit to the demands because they don't want to get into police issues. The fear of arrest for a law-abiding citizen is the greatest fear. So that's where they have added extra layer. So all senior citizens, if at all anybody, any police officer comes and threatens you, you can be rest assured under the code, provided it's not a serious offense, of course, that he has no powers to arrest. He has to take permission from the higher officer, and that means that the higher officer will discharge his duty. You can expect that in keeping with the requirements of the society. Then information to the public by, now I'm not sure, this goes both ways. They've said that public should be informed about all persons who are arrested. Now this can go both ways. Nowadays, if the arrest is arbitrary, one can say that it amounts to sullying one's image and reputation. But the other way of looking at it is that at least people know who are the offenders and whom you have to stay away from. Then they've introduced technology. So this is important. Now, search and seizure. Many a times, when police come to search, if there is an agenda, if it is a motivated investigation, a motivated complaint, they might just put something in your bag at home and say that we found this particular material. It could be drugs, could be a substance which is illegal. But now they have to videograph it, which ensures that there is transparency, and one cannot then manipulate it. So this, I think, is quite protective of the rights of the persons against whom these search and seizure operations are mounted. We've seen that many a times people who cheat, they get away. You file a 420 complaint, you file an FIR, you file a charge sheet, you file a case, but the person has cheated you of let us say 50 lakhs of rupees. So the matter will go on for years together. There was no power given to the police. So that is where the seriousness of the crime can be first imposed on the concerned accused. At the same time, one can enforce it. Because let us take it that about 50 lakhs is, you're duped of 50 lakhs or maybe 10 lakhs. So this is giving powers to the police to attach the accounts. Because we feel helpless. We go to civil suit, it goes for years together. Criminal cases, they will be, if at all they are convicted after 4-5 years. But what happens to my money? I'm cheated as on today. So to address that, they've said, well, we'll attach. They have powers now to forfeit and attach maybe a bank account or their property. So that is what was not available. They've been given more teeth so that they can, as far as possible, make sure that the criminal or the accused is constrained. Today, they take advantage of the system and the fact that the trials go on for years together. There's also an addition, I'm not sure how many are aware, there is a provision under CRPC for maintenance. So now they have, and the problem was that the maintenance had to be filed in the jurisdiction where the child was or the person from whom you're claiming maintenance was. So now they made it more senior citizen friendly or the person friendly to say that you can file the case for maintenance within the jurisdiction where you reside. Then zero FIR. If there is a crime committed, a citizen is not aware of what is a cause of action, where I should file an FIR. And this is where advantage is taken by the accused or the criminal. And then the whole matter goes into a technical issue of where should have registered the FIR. So now they have said that it doesn't matter if the complaint reflects that there is a cognizable offense, register the FIR wherever the complaint is filed, make it a zero FIR and then send it to the concerned police station. Because as much as we want citizens to be aware about where to file the complaint, it can be a little technical, where is the cause of action arises, where is the crime committed. It keeps changing, and as lawyers will take advantage of that. But now they've said, wherever it's committed, every police station can register 0 FIR, and then you can send it to the concerned police station. I think this is very citizen friendly. Then forensics, I think the takeaway from this particular page is forensics have improved. Now it's the investigation is more scientific, and that will, I hope, will ensure better crime prosecution rates. Then there are checks on power of police while conducting search, because he has to record grounds of belief. And even exemptions are given to from attending police station to women, aged and ill persons. So if you see the additions, even in the investigation, people feel they are harassed with their senior citizens or women. Now going to police station invariably, creates a sense of fear. So that is sought to be assuaged to a great extent by trying to make it a little more convenient for the people or section of society that is most vulnerable, that is women, aged and ill persons. So this is with regard to the investigation. There is for convenience of witnesses. Now witnesses were also going through harassment when it comes to, if they're witness to any particular crime or part of any criminal case, they had to go to courts which were kilometers away. They were called time and again, multiple times. That was one of the reasons why there was nobody coming forward to give statements or participate in the investigation. But now they've incorporated provisions for convenience of the witness. And from a victim's point of view, many times you file a complaint, you don't know where it's going, the investigation. So now it's made mandatory for the investigating agency to communicate to the victim the status. What is the status of the investigation? So examination of witnessing technology is brought in. So all this will make the trial easier. Hopefully, will expedite trials, and sometimes expediting trials by itself will lead to higher conviction rates. So they've curtailed adjournments. They made it a little difficult or challenging for the prosecution to take adjournments. Hopefully that's implemented. Implementation is a casualty in these cases. And a lenient approach. Now you can do some plea bargaining. So plea bargaining, for those who don't understand, I'll take a minute, is if you're charged of 2 offenses, then subject to certain conditions, you can say, well, I'm charged of 2 offenses, I will accept one, provided you let me go in the other. So that is now made official. It's available in US and other developed countries. So now you can do that plea bargaining, but you have to accept that you have committed some crime, which could be lesser of the 2. And you can say, I'm accepting this crime, not the other, and you can bargain with the prosecution. Yeah, then there is a witness protection scheme, and there's a protection from arrest. Because I'm sure when you talk about police, the major concern of every citizen is they should not arbitrarily arrest. And that's where there are a lot of safeguards and checks and balances which are there in the new system. Now this is the last act. This is very technical. Evidence is something where you need, the lawyers really need it as a part of the trial. All I will say is that they have introduced technology into evidence. So again, from the citizen standpoint, hopefully the trials are expedited. Hopefully the evidence is qualitatively better, and we hope that if ultimately implementation, as I said earlier, has always been a casualty. So if all these principles of the Evidence Act are incorporated, wherein new technology is put in, because now we communicate by WhatsApp, by emails, the days of letters and AD cards are no longer, you can almost say it's a passé. So therefore it was a need for even the Evidence Act to update itself, which they have done. So there is electronic evidence, faster evidence. It's, according to me, more credible evidence, and should also lead to a better and qualitative prosecution by the prosecuting agencies. So I have tried to, first and foremost, stick to the time. And I didn't want to make it technical. I've tried to make it as simple as possible. As much as you can take away from this, I'd be glad if you can take away something out of each of those three. But all that I can say is that when it comes to the first aspect, do a little, the preamble, the constitution, do a little more study. Just read it like you read a newspaper. Try to understand, because you should be a more aware citizen, and you should not be really in any manner suppressed or taken advantage of. You should just exert your right and be as firebrand as a citizen as Rui is. So, and the other part is about the three other acts. As I said, they are required. My conclusion will be it was required. They've introduced some very important concepts, crimes, punishment concepts, procedures, in keeping with the present day technological advancements and requirement of the day. So thank you.
Thank you, Advocate Shivam. He is truly an enlightened speaker. He is a truly enlightened son of Shivan Desai, a senior advocate. And now it was a pleasure to have young advocate Shivan Desai, who I'm sure elaborated and enlightened the audience with his given time frame. Before we move into the question and answer session, let us unwind a bit and have some patriotic music.
You organize this function. My question is, you have very comforting answer for us so far as the basic feature of the Constitution of India, and we are not able to change it. It is not a simple task. But lately, F.S. Nariman, before he died, he has written a book saying that I was born in a free India and I have flourished in a secular India, but I am not sure whether I am going to die in a secular India. He was so much non-specific about the future of our country. What is your opinion about our secular India continuing in future?
See, that's the reason I addressed it and pitched it that way, that there is a lot of rabble-rousing which happens in the society. But the point is, when it comes to the citizen, you as a citizen, irrespective of your background, and let me address it straight away, whether it's religion or caste, there is, under the law, there is absolutely nothing that can be done to discriminate on that basis. There are enough and more provisions under the Constitution. So what you read in papers, sporadic incidents, I think I use the expression "don't react," and that's the reason I said so, because the reaction is where the problem is. As long as you know that you're secure, you know that the law cannot be changed irrespective of whatever may be the rhetoric. There's a lot of rhetoric which happens, which conditions the way we think, which should not be. That's where I come from. Please understand your constitution. Please understand that nobody can really do anything to interfere with your life, your thought process, your belief, your faith, your profession, and your existence and dignity as an individual. So that I think it's more of a reaction based on perception, and that's what needs to change, if you ask me.
Good evening, everybody. So I had one question. In Goa now, we are having plenty of accidents all around us. And mostly people will come, take videos, circle around you, and they will move, and they will not witness, or they will not try to help, with the fear that if they try to help, if they try to be witnesses, they might face consequences, or the law might be after them. So how do we
So precisely, that is what is sought to be addressed. If you see the provisions I pointed out, one is if you're a senior citizen, women, then you don't have to go to the police station. They'll come wherever you are, record your statement. Then in convenience to the court, they'll make sure that you don't have to go to court. You can record evidence from wherever you are electronically. So these are measures. There is a witness protection program. If he's an influential criminal, then there is a protection program, which is, so you have actually hit the nail on the head, because this is precisely what is addressed here. The inconvenience and the apprehension that people have to participate in the investigation process, to assist and make sure that the criminal is brought to book, is to a great extent eased by the new code. So that's where you don't have to really make the rounds to the police station, rounds to the court, and you don't really have to fear anything, whether it's the police or the influence of the concerned criminal. That's where I think these kind of seminars make a difference. These kind of seminars go a long way, and that's, I think, is the objective of this seminar, that you are aware of the basic rights so that you're not exploited. You can live with dignity, and you can be a citizen of equal rights in this country.
Yeah, so thank you for, you say don't ignore the rhetoric, but it is hard to do. I think in Goa we live in a bit of a bubble, but if we just cross the border and go to the other states, so I won't beat around the bush, I'll talk about the issues that affect minorities largely. Cow slaughter, buying and selling of beef, love jihad, and conversion. These issues, I mean, we talk, there is stuff in the papers about anti-conversion bills and the fear of things like that. Fear of freedom of speech, people being arrested under UAPA for a tweet or something being deemed seditious. So all those preambles, those principles are supposed to protect us, but in practice it's not happening.
Yes, if I kind of, I was expecting something like this, but I understand where you're coming from also. But as I said, that is to a great extent, what the WhatsApp University wants to achieve, and that's that creating that sense of fear in you. Point is, ultimately, the courts uphold the law, and nobody can be put in a position whereby he is denied of his fundamental rights. Fundamental rights, if you have a right of freedom of expression, it's of its highest ideal. So even if, this Arnab Goswami case also, where depending on the political scenario, one can misuse it, no doubt. There is collateral damage, but eventually now, the law is streamlined. Even if PMLA is abused, I agree with you, freedom of speech to a great extent was curtailed. It's freedom, it's fundamental right, cannot be curtailed, cannot be taken away for any point of time, but they were misusing certain provisions. But if you see the trend now of the judgments, they are absolutely clear. They've quashed anything and everything. Even today, I think, if you see Justice Menezes and Justice Sonak, last month, quashed that case against the priest, I think, father. Then even yesterday, there was another case. So at one point of time, since the political climate is in a particular direction, sometimes, the wind is maybe in whichever direction. But one thing is very clear. This is not just on the books. This is something which is something that everybody has to respect, and you just cannot trample upon anybody's rights, irrespective of his background. So I think it's a lot of WhatsApp University which is driving this, creating that sense of fear. But whatever I've said today, it's not on paper. It's implemented. It's implemented on a regular basis by all courts.
Hello sir, my name is Deeksha. My question is, like you were talking about that equality thing about journal quota. The thing is, I agree with the fact that scheduled caste and scheduled tribes should have the right opportunity. But I just want to know, it's okay if the seats are reserved for them, but do you really think that there is a need of reducing percentage of marks here as well?
Yes, it's slightly because, see, I have a particular point of view, and that is that it's when we say that, there has to be equality, and I'm, putting in my efforts, I'm studying so much, and somebody who is getting less marks is in the same position as me, or I'm deprived of my seat because somebody else. But you need to understand that you are exposed to, your parents are in a position to give you the best education, best infrastructure. You can go to the best institutes, best coaching, tuition classes. So you imagine this as against somebody who is a scheduled caste, scheduled tribe, where he doesn't have this assistance. Nobody is born intelligent. There has to be certain element of grooming. There is a certain element of coaching, tutoring at home or at institutes. And that's what ultimately helps you in your performance, as much as one may like to believe that we are born intelligent. But people who don't have access to all this, you can't compete. It's not a level playing field. It's not because he's not intelligent, he's daft, and that's why, unfortunately, because of less percentage now, he's getting benefits. The problem is a level playing field can only happen when he's given the same opportunities, and possibly it happens in the next generation after. That's the process. That's why you have the creamy layer. But to say that, to have the same percentage or compare them at par, I think is not quite fair. That's my reading. But what you say is the perception of a lot of people. You go through it. Possibly must have, had the rough end of the stick on this aspect. But this is the concept. We possibly in Goa, as I think Sir said, that we live in a bubble. But if you see rural areas, even Kankon, I've interacted with some of these tribals, scheduled tribes. It's been 75 years, but things haven't changed. So there is a need to uplift them. And I think I'm in the minority, but I strongly believe that this is how it should be.
That was a fitting answer to your question. Now I call upon our prayer group member, illustrious Advocate Teresa Culasso, to raise a vote of thanks.
Pleasant privilege and task to thank everybody gathered here. First of all, my dear colleague Shivan, for coming here, for elucidating this whole audience on the preamble, first of all, and then the other three laws. The preamble is a very important part of the Constitution, and really, some of y'all over here will really get to know the Constitution better by what was spoken by our speaker, Advocate Shivan Desai. And so on behalf of the CCR, Community of the Way Prayer Group, and the Goa Jesuits Social Action, and Father Joe Nazareth, who is very, very good in all these things and active. I thank each and everybody who has been here present today. Thank you and good night.